I'm supposed to sign a mortgage at my closing. What is that? Hi, I'm Mark Stiles of Stiles Law down here at Studio B. So you're getting ready to close, whether it's a refinance or a purchase, and one of the documents that will be asked to be signed is the mortgage. What is that? Well, we talked about the promissory note. The promissory note is the agreement between you and the bank. The bank agrees to lend you money. You agree to pay it back at a certain interest rate. But what if you don't? Well, the bank would have to sue you. Now, if they had a security instrument, then they wouldn't have to, and they could redeem through that instrument. And that's why this document is so very important to the lender. It's a security instrument. The mortgage acts as a security instrument. Your deed will go on record providing proof of ownership, but then you will grant voluntarily a lien on your property, a voluntary lien, if you will. And that's what the mortgage document does. It secures the lender's loan to you. It secures their note. So if you look at that document, it's a very long document, much longer than the promissory note, and it says who the borrowers are. You, Robert and Barbara, borrower, the date, and your lender. And there's a number of definitions and terms. States today's date. It also states the maturity date, when the final payment is due, as well as the amount secured. Similar to the note, this is a Fannie Mae uniform agreement used by virtually all residential lenders for both primary, secondary, and investment properties. The uniform covenants speak to how payments are received, how they are accounted for, the application of the payments or the proceeds. What is accounted for first? Interest, principal, or escrow? As you'll see here, the money shall be applied in the following order: interest, due on the note, then principal, then amounts due under the escrow provisions. It speaks to the situation where you may not pay your taxes and insurance, and what the lender's rights and obligations are to pay those for you, because they want to protect their position. Most often, a lender will want to be in first lien position. So again, you have your deed that provides ownership, and then you release certain rights, the voluntary lien, back to the lender by recording this mortgage. The lender wants to make sure that there are no other liens in front of that. But what happens if other bills or liens are outstanding? Well, the lender has the right to go ahead and make those payments to protect their position and bill that back to you. Same with property insurance. They want to make certain that you have insurance, because if there is a catastrophe, that will affect their secured position. So if you fail to make payments to your insurance, they can purchase insurance for you. That's called forced place insurance. Typically, this is much more expensive than the insurance that you can get as a consumer. If this is your primary residence, you will see the occupancy provision that you're agreeing to, that you will occupy and use the property as your principal residence within 60 days after the execution of this security instrument. And you shall continue to occupy that property for at least 1 year after that date of occupancy. The lender wants to ensure that you preserve and maintain and protect that property because it's in their best interest. Another question we get very often is, what about joint and several liability? What if one of the owners of the property does not pay? Does the other have to pay? And the answer is yes. Joint and several liability means the obligation of the group is also the obligation of the individual. So if one individual cannot make payment, the full obligation may lie with the remaining individual. One of the most important provisions that we see in the secured instrument called the mortgage is number 18, the transfer of property or the beneficial interest in the borrower. This is very important when folks want to sell their property and have the buyer assume their loan. This would trigger a default because the lender has not qualified that new buyer. Therefore, they have the right to accelerate payment and be paid in full. But what about estate planning, you ask? We're often confronted with the folks that want to transfer into a trust. Well, that is an exception. If you're looking to conduct estate planning and you want to transfer your property into that estate planning trust, that is an exception to this provision. What happens if you fall on hard times and the bank has defaulted and accelerated the note? Do you have the right to bring it current? And that's what provision 19 speaks to. And of course, as we know, lenders tend to sell the servicing and the rights and ownership of these debt obligations. And that's what Clause 20 speaks to, is their ability to do that, but they must give you notice so that you know where to pay. In keeping with the theme of protecting the lender's position and their asset, you cannot store hazardous substances on the property. And then in Clause 22, you'll see the acceleration and the remedies in bold print. This is very serious and very important to understand. Many people don't think about this at the outset and the origination because they always intend to make the payments, but the lender will always look to worst case scenario. And this lays out unequivocally how they're going to proceed if payment is not made. And by utilizing the statutory power of sale, this is what grants them their rights to conduct a foreclosure auction, thus taking back their position when payment is not made. All documents that are to be recorded at local registries of deeds in Massachusetts must be notarized by a Massachusetts notary commissioner. And then finally, the exhibit. The exhibit is your property description. What are the metes and bounds? What is the location of the property that's being mortgaged? This will match your deed. Remember, your deed is your ownership. The mortgage is what you've delivered voluntarily to the lender so that they will lend you the money. I hope this makes sense. I hope it makes your closing go smoother. If you have any questions, please don't ever hesitate to reach out to us here at Stiles Law. Thank you, and be well.